All right. Well, good afternoon, everyone, and welcome to the Bonavero Institute of Human Rights. Welcome to those who are here in the room, and also those of you who have joined us online this afternoon. My name is Başak Çalı. I'm a professor of international law here at the University of Oxford Law Faculty and head of research at the Bonavero Institute of Human Rights. And it's a real pleasure to welcome you to this joint event that we're hosting today, together with the Institute for Ethics in AI, also at the University of Oxford. So the title of our event and discussion today focuses on the Council of Europe Framework Convention on Artificial Intelligence, Human Rights and Democracy. And the title, as you might have seen, talks about promises and shortcomings. One of the key reasons we wanted to hold a discussion on this convention is because it's just been adopted nearly almost 6 months or so ago. So the adoption of the text was on the 5th of September 2024. And I think this is highly surprising in a world where multilateralism is very quickly, decaying and under huge challenge, that a convention, let alone on anything but artificial intelligence, human rights, democracy, and rule of law, was actually adopted by the drafters. So this is something that we thought was really worth understanding a bit more. And that's one of the key reasons why we also wanted to convene this event. When we look at the convention, it seems it's very unique because it was negotiated, even though it's a Council of Europe convention, actually the negotiators were quite global. A lot of countries that were outside of the Council of Europe and the European Union also participated in the negotiations. There were civil society participation as well as other stakeholder participation. And after its adoption, only 14 states so far signed the Framework Convention. So obviously this number may increase. This also means that the convention is not yet in force because no other state or no current state actually ratified, as of today, the convention. But if we look at who signed the convention, so this is after last September 2024, we see that the United Kingdom is one of the signatories, as well as countries like Georgia, Republic of Moldova, and Norway, amongst others within the Council of Europe. But also the convention was signed by the European Union as an entity in and of itself. And it was also signed by the United States, Canada, Japan, and Israel. So it makes it an unusual text in terms of support at the level of signatories. So this convention, as its title suggests, is a framework convention, which means that it's neutral as to what happens in terms of the substance of the development of technology. And it's something I hope we will be able to discuss later on as well. So today I'm really lucky to be joined by an outstanding group of experts, I think, who are the best placed people to be able to speak to us about this, what I call a very curious convention. And let me introduce them to you very briefly. First, and also they will be speaking in the order that I'm going to introduce them to you. We have today with us Professor Mario Hernandez Ramos, and he is currently the chair of the Committee on Artificial Intelligence of the Council of Europe. And it was this committee that drafted the convention, and it's also this committee who's working on the implementation program of the convention. Maria Hernandez Ramos is a professor of constitutional law at the Complutense University of Madrid, and he has been serving on the Committee on Artificial Intelligence since the creation of this committee in 2019, and he was the head of the Spanish delegation throughout the negotiations, and he's currently the chair of the committee. And I'm also joined by Dr. Angela Müller, who is the executive director of Algorithm Watch Switzerland, and also an executive board member of Algorithm Watch, which is incorporated in Berlin. She is responsible for the overall strategy of the organization of Algorithm Watch, and also its work in the field of policy and investigations. She has also participated in the discussions around the negotiation of the Framework Convention on AI, human rights, democracy, and the rule of law. I'm also delighted to be joined today by Professor Thompson Changeta, who's a professor of law and AI technologies at the Liverpool John Moores University and a supporter of Liverpool football team, as far as I know. He's also a board member of the United Nations Secretary General's 15-member advisory board on disarmament matters, and he is also a commissioner of the Global Commission on Responsible Artificial Intelligence in the military domain. Another kind of really important role that he currently has is as principal investigator in the African Commission on Humans and People's Rights current study on the implications of artificial intelligence. And I'm also today joined by Semeli Hajiloziu, who is a researcher at the Alan Turing Institute and co-organizer of the Institute's Artificial Intelligence and Arts Interest Group. Semeli is an interdisciplinary researcher, and her work examines socio-technical implications of data and artificial intelligence intensive technologies. But she has also been working in the very recent one of her tasks in her role has been also to co-develop the human rights, democracy, rule of law, risk and impact assessment methodology together with the Committee on Artificial Intelligence, and she's also going to be talking to us about implementation or possible implementation of this convention. So a really big warm welcome to all of you. So our panelists are free to come up here to talk, or they may choose to sit. So it's really up to you. We've talked about that. And I think we're going to start with an intervention by Mario to start with. And I think one of the things that we would be very keen to hear from you, Mario, is how this convention, how the drafting of this convention started, what were the biggest issues that came up during its negotiations, and also, it's a 6-month-old text on one of the most important issues of our times. How do you see it going forward? Thank you.
Thank you very much. Zach, can you hear me? Thank you very much for the invitation to the Bonavero Institute of Human Rights, the Oxford University. It's a pleasure to be here, and I'm very happy to see that the Framework Convention is interesting for such an important university, and also for the United Kingdom. That I must say that United Kingdom was a country that pushed very hard in the elaboration of this convention. The creation of the United Kingdom was very implicated in the elaboration of this convention. So this convention came about in the meeting of the Committee of Ministers of the Council of Europe in Helsinki in 2019, where they were discussing the future role of the artificial intelligence regarding human rights. We could devise that, of course, artificial intelligence with technology that affect in a very important way to the human rights, democracy. So they decided to create an ad hoc committee, the Committee Ad hoc of Artificial Intelligence, in 2019, December 2019. That was the first meeting. And in that meeting, we decided to create several working groups and the methodology of the work. And after 2 years, discussing and elaborating about a feasibility document, it was a possibility to elaborate an international treaty regarding artificial intelligence. We finished with a document, and we tried to explain and we tried to give some answers to the main questions of: is it possible to have an international treaty, to create an international treaty to regulate artificial intelligence related to artificial intelligence, to human rights, democracy, and rule of law? What would be the main problems and the main topics? And this feasibility work was very important because we could allocate and we could identify the main hot points in order to keep working in the next phase of this committee, the Committee of Artificial Intelligence, that now is working. And I can think it was not an easy job. because we need to face two important problems, mainly two important problems, regarding the scope of the convention. The first one was the national security. Of course, all the countries were very worried about the limitation in the use of artificial intelligence in national security. But surprisingly, this was not the main problem to reach an agreement, because we solved it in one night. In the last meeting that we hold in May 2024, national security, we agreed mainly of the countries with a kind of compromise wording of the Article 3. That was not problematic. The main problematic point about the scope was about the privacy. That was the main problem for us and for all the countries. And there was not a question of legal technique, like for instance, if through an international treaty can we regulate or can we push obligations to the private sector? But also, some countries that don't have private sector and artificial intelligence, are we in a position to impose to other countries who hold important enterprises with artificial intelligence? Are we in the positions to set some obligations? And that discussion started in the very beginning, and we couldn't solve it until the very last day, until the very last moment. So that was, from my point of view, the most delicate topic. Of course, there was other problems, for sure. There was a decision, for instance, there was a dilemma, whether we should design an agreement for a very wide number of countries with different legal backgrounds. So you want to reach many countries with different legal backgrounds, you need to draft the obligation in a very general way. But if you want a very specific bill of rights or specific obligations, of course, some countries are difficult to agree on how to draft the specific obligations. So in the end, because also European Union regulation on artificial intelligence was being discussed in a parallel way, we decided that maybe we should bet for a complementarity relationship between these two European instruments and not to replicate the European Union regulation. So we bet for try to design and try to identify the most important principles that should be present in the different steps through the life cycle of an artificial intelligence system, and not to be very specific. Not to be, of course, not very ambitious, because I think the Framework Convention is quite ambitious, but we could be agreed on more. Right? So I would like also to stress that it was possible to reach an agreement in such a short time because all the delegations were very implicated in the wording and positions. I would like to stress the United States delegation, United States of America delegations, who were very, very interested in the happy outcome of this convention from the very beginning. So sometimes you could read some in the social media that United States of America were trying to water down the level of the compromises and human rights, but they were from the very beginning very honest and very clear about the principles and about the scope they wanted to agree on. And they maintained that position. And they pushed very firmly in order to get to that point. The European Union also was the other key actor on the negotiation. European Union, of course, with the 27 countries. So those were the two main actors in the negotiation of this Framework Convention, along with important countries like, of course, United Kingdom, Turkey, and the civil society, which were very helpful, trying to, well, reflect some problems regarding the scope, mainly the scope of the Framework Convention. And well, in May, we finished the work, and it was a happy day because truly, I thought we didn't finish. We didn't agree on the convention. It was in the last day, in the last night, in the last plenary that we could agree on that. I thought that was a Spanish way of doing things, but no, it was like a very European or universal way of doing things. Maybe that is the diplomatic way of negotiation. And so we have a convention now with very general principles, but principles that can be agreed by countries from very different perspectives and legal backgrounds. We have European countries, of course. We have an European organization like European Union. We have United States and Canada. We have Asian countries like Japan, but South Korea is very interested also. We are talking to him. We have also in the committee Latin American countries. We have Australia. Australia is working also in the CoE. And now in the current CoE, we have like observer status. We have a conversation with Morocco, Tunisia, and other African countries. So this general perspective allows many countries to sign the convention and to have a common standards and a common understanding in how to face the challenges that the artificial intelligence brings to democracy, rule of law, and human rights. And in order to end, because I don't want to take a lot of time, nowadays there is a kind of not optimistic wave of regulating artificial intelligence. Well, I like to think that regulating will happen, because regulating is like, we need to regulate when problems regarding artificial intelligence with human rights arise, and I go to a judge in order to ask to solve a problem, the judge will have to answer. If the judge has no specific norms, it will have general norms. So the judge will have to develop and to construe very general rules in order to give a specific answer to a specific problem. And that is a problem for democracy and for the rule of law. So sooner or later, the regulation will arrive. So it's better to have it now, to have it in a clear way, because of for the sake of the principle of legality and legal certainty. And I think this perspective from the Framework Convention is the proper one, like general principles that must be developed and to be done by the national authorities.
Thank you. Thanks very much, Maya. So, Angela, your algorithm watch took part as one of the civil society organizations and followed these negotiations. What is your take on this convention? What kind of makes a bit of a more positive assessment of it? But what aspects you see are positive? What are some important gaps, if there are any? Has it been successful in its aim of providing a regulatory framework for artificial intelligence? And perhaps you could also reflect on the role of this convention and what probably we see as a very crowded space of standard setting. The European Union was mentioned, and there are lots of other initiatives, both treaties and guidelines and standards. So how do you place this convention in this regulatory framework?
Yeah, thank you, and thanks for having me. Hello, for the great introductory remarks. We were, of course, discussing the convention several times before. And I also want to start like with the positive sides that I see. And I think the most important thing is that it sends a very strong signal, because the first international treaty that we have on AI is a treaty on protecting human rights, democracy, and the rule of law. It's not about markets, economy, trade, whatever. It is about human rights, democracy, and the rule of law. And I think that signal couldn't be stronger. So I think that in itself, just that the fact that there is such a convention is very important. And there's also been a long process behind, as I described, from high to high and so on. It started like in 2019, went on to 2024. And I think what is really important also when you think about the process and the time is that, like, I think the negotiations have never been blindsided by this generative AI hype. The convention makes it really clear, and that was part of the negotiations from the beginning, that, or like it acknowledged there's uses of algorithms and AI in very sensitive areas by states, by companies that affect people's rights, and it's not only about generative AI. And I think that's very important. Yeah, civil society has been very active along this process with some backslides, I must say. We were excluded like from the real discussions that took place at night, like the decisive ones in the end. But yeah, there has been also a bit exchange with several stakeholders in the negotiations. And then like I feel it's somehow the convention is like 2 steps forward, but also 1 step back. And because it sends such a strong signal that there is a convention on AI that focuses on human rights, we also have to be aware that it sets a precedent, right, in international law around AI. And I have like 4 major worries in this regard, because it is this precedent. The first is that the vague language that it finds, right? I mean, you can find like the phrase, it seeks to ensure, to seek to ensure something. And I think that just, doesn't adjust for the fact that, states just have to respect, protect, and fulfill human rights and not seek to ensure something. Also the use of general principles and so on. So I think that is a watering down that has happened over the course of the negotiations. And it's definitely a pity. The second has been mentioned, like this exclusion of national security, because I think that's actually an area where, a lot of people are actually impacted, or a lot of people's rights are actually being impacted. And also because it's a very vague term, right? What states understand as falling under national security. I mean, think of the variety of states we're talking about here, that could just serve as an excuse not to, apply things under this umbrella term of national security. A third point is that also something that was discussed in the negotiations is that in these times where we have like this bigger is better mentality around AI, where it's larger and larger investments into bigger and bigger models that actually have quite an environmental footprint, that the consideration of environmental aspects was part of the discussions, but it didn't make it into the final convention. So there was initially an article on environment, and that was erased from the final version. And I think that's also like one of the downsides. And my 4th point being that, this is a convention on human rights, democracy, and rule of law. There's also articles on democratic integrity and so on. I think that's really important. But also in times where we know that democratic discourse and deliberation is highly influenced by private actors, and highly curated also by private actors. I think the fact that the convention leaves states the opportunity to touch private companies only with very light measures or with non-binding measures is also a downside, because it ignores that currently there is no AI without big tech. It's as we discussed before, it doesn't fall from the sky. And I think if we're okay with saying, you know, we don't need to set strict rules on private companies when it comes to AI, then this sets kind of also a problematic precedent. And then you asked, what does that mean for like other norm setting or standard setting discussions? I think both. It sends this important signal. You know, when we talk about AI, we really have to consider what it means to human rights, democracy, and rule of law. But also with this problematic precedent, because it's like, you know, those actually benefiting right now most of this kind of technology can be left unchecked. No need to hold them accountable if you do not wish so. So I think that's really important. That that's also why I welcome like the discussions around like, you know, how can we strengthen actually the international human rights law when it comes to AI, because I think that might also, the convention might also send like mixed signals here. And I also think what is important in this norm setting discussions is also like at the national level, that, you know, states are willing to, in a way, overcome these shortcomings when they, for example, implement the convention, right? Because they have to implement it at the national level, so they can still be very ambitious and try to set, you know, standards there, and also send a signal for ambitious national level implementation. And also, that's also part of what we discussed this afternoon, is that I think that the goal should really be to have like a strong protection of human rights, democracy, and rule of law when it comes to AI, but to embed this also in a like broader strategy that, on the one hand, right, that you are able to address negative impact, that you are able to address impact on human rights. But at the same time, you also need measures to really ensure that society is benefiting from this kind of technology, that, you know, that this is innovation that benefits all and not just human and so on. And maybe, yeah, to end on the same note as you did, like in these times of deregulation or massive calls for deregulation, or also threats to states who wish to regulate, I think such a signal is clearly needed, like really a strong signal. And also, I think there is really action needed to ensure that this convention, you know, can be really a major or piece of the puzzle around AI and how we can actually make sure it benefits all of us. I don't know whether it's this convention, or I don't know whether we need other kinds of treaties around AI. But it's definitely one, you know, a puzzle piece that should be at the center of our discussions around AI. And I hope actually the convention doesn't lose its significance for the intentions of the course.
Thank you very much. So, Thompson, if I may turn to you and ask you a couple of questions. Of course, I'm curious about what your take is on this convention, because you're involved in a lot of different regulatory discussions around artificial intelligence, and also in the context of the African Commission's kind of study on this. And is there anything unique? Is there anything special? You know, is there anything that's important about this? But also how you also see the shortcomings, perhaps, of this regulatory model. And perhaps you could also reflect on questions around effectiveness of how we regulate these systems, both in the, I know that this is mostly covering the civilian context, but not the military, and your takes on these questions. Thank you.
Thank you very much for questions. A very good evening, ladies and gentlemen. I would like to start by just stressing that I promise this is not going to be a lecture. It's just I'm just going to pick the 5 points that I want to say, and I want to firstly actually start by thanking, you know, the invitation from the organizers, but more fully also framing the question in terms of promises and shortcomings. Because if you had just said, you know, a critique, for example, I have a problem that I then become just like an Arsenal or Man U fan. They're always complaining. But in this particular one, I'm just going to try to look at both some of the strengths and the weaknesses from this convention. So first, I have really to start by thanking and appreciating the Council of Europe for coming up with this really convention. The first strength being it being a conventional framework on AI governance. The idea for me of understanding a conventional framework, as you rightly say, is that you're coming up with general principles that states are actually agreeing, especially in this fast-moving field of AI and emerging technologies. And again, a conventional framework, in most of the times, you're able to end up having additional protocols, additional rules on specificities that states may want to govern. And I must say that, for example, within the African Commission study, and many other interventions that have been participating, this is being given as an example of what could actually come up in terms of regulating. Say, maybe let's start with a framework convention, general principles that we agree. Something in the GCVM, this is a discussion that is going on to say a conventional framework, makes you start somewhere and it's general principles. And there are several examples of conventional frameworks which have additional protocols on specifics. And I think this is a field that benefits from that, which is a strength. Secondly, I also want to acknowledge from the beginning that is a human rights-based approach to governance. That in itself is a strength that we need to acknowledge. Why? Because generally, there are several options, so to say, to regulation or to governance that are being flighted. Others have been saying risk-based approach. Others have been saying, well, technology-based approach. And the human rights-based approach, which has been taken in the convention, I think it needs to be applauded. And if we were to really give a comparison, actually, in terms of strength, you'd find that the findings for me of the United Nations AI high-level body, particularly on page 39, box 7, are very, very informative. They actually say, having taken an intensive consultation of several stakeholders, the most popular approach in terms of governance that found resonance and support from everyone was a human rights-based approach, also located in international law. So the convention actually doing that, the framework convention doing that, it's really a strength that we have to mention. And we have actually, the same approach, some things being mentioned in UNESCO reports, in the African Commission resolution, we are finding the same aspects. Now, as an African, it would be really an amiss for me not to mention, some of the key principles or foundational norms that you find in the conventional framework. The question of human dignity, as in Article 7. For many people who have been on the receiving end of inequality, violence, particularly countries from the African continent, for example, the question of dignity, which we sometimes call Ubuntu, I am because we are because I am, is an important foundation for whatever regulation that we try to come up with. And you find that in the discussions that are currently ongoing, the question of human dignity is actually a center norm that actually is being emphasized there. And this definitely is a strength. Now, again, I now move a little bit now to limitations. Though the Framework Convention, for example, mentioned the question of equality and non-discrimination as foundational norms, their preamble, it is an important norm that we actually do agree and emphasize. The only limitation that I've noted there is that there is express mention of gender, which is a very good thing because gender equality is critical. But apparently, there's also a clear non-mention of other grounds that are important as far as non-discrimination and equality are concerned, that are at the core as far as AI is concerned. Race, disability, and many other identified. This is not by accident. For those who may be in the history of making of international law, you know that the United Nations Charter, for example, during the negotiation, there was specific mention of identifiers such as race. States refused to include them. That's why the UN Charter today just mentioned gender as an example when we're talking about discrimination. This, to some of us, scholars from the global south, would say it's perhaps a continuity of what we call neo-coloniality of international. Identifiers that are comfortable in certain aspects, that are the ones that are actually mentioned and emphasized. Now, I would want to again move to the question of strength, move a little bit from the question of weakness. To say, I like that the Framework Convention, when it comes to new terminologies, which I saw as one of the problems that are existing as far as governance is concerned, that there are new terminologies such as risk mitigation, bias mitigation, which are being adopted as principles of AI ethics. And I've always said, when you are saying bias mitigation, that's not human rights language. There is prohibition on discrimination, there's elimination of discrimination. The convention actually captures this correctly, contrary to many documents actually who talks about bias mitigation, which we say it's a standard which is lower than what human rights law say. Now, coming to my almost last point, second from last, which is a limitation, I will not spend much time on this, is to mention what my colleague was actually mentioning right now. The exclusion of certain scope of application, national defense, national security. There's so much literature in human rights jurisprudence that talks of certain rights that are absolute, which doesn't matter whether they're talking about national security or, those rights are absolute. By merely excluding an area that actually disadvantages certain states, particularly from the global south, for me, I think it's a major weakness. For example, already, human rights violations at the instance of military AI is already ongoing in certain regions. I don't think there was a reason really to say we exclude this. If you look at the recent report of the UN Human Rights Council 2025, this last February, a couple of weeks ago, in its study on the human rights implications of AI in the military domain, make the same point to say for years and years, we've been saying human rights, of course, applies in armed conflict, applies to national security. There's no reason when we're trying to govern AI to exclude this. My last point is question of data governance. I see that in particular Article 11, there is a focus on privacy when you're talking about data. But one of the key issues that concerns states from the global south or people from the global south is data colonialism, data exploitation, which is a key issue in terms, if we're talking of comparisons of what we're saying we want to regulate. Yes, privacy is an important aspect, but equally other questions of appropriation. And in this conclusion, I will say, what are we trying to do with this framework convention? We are already being asked questions to say international norm framework. Again, I must end on a sad note that it feels again as a history repeating itself, where Africa has to catch up to treaties negotiated in their absence. To what extent are the principles which are agreed in the negotiations here, which are now being put to the world, actually reflect everyone's values? I would want to end on that, and ladies and gentlemen, I thank you for your attention.
Thank you very much for that intervention. I think that, as we're moving from one speaker to the other, the clock thickens a little bit, and we're getting more and more into this thing called the Framework Convention. So the last set of questions I'd like to pose to Senator has to do with not the scope of it, so what it covers, what are the kind of the norms and languages that are included, but also the vision of implementation. Because one of the things when you adopt these instruments, there's an idea that they will be implemented. And of course, this brings us back to the fact that this is a framework convention, which means that the core idea in its vision of implementation is that there's going to be an ongoing impact assessment of artificial intelligence systems throughout their life cycles, as that's what the treaty says, on human rights, democracy, and the rule of law. So the idea is that there will be someone else who's going to be looking at the severity and the seriousness of the impact of these evolving systems on these three values, right? So this is the kind of vision. And of course, this requires doing some impact assessment, or people understanding how to carry out impact assessment. And Senator, I know that you've been working on this aspect of how to actually develop a methodology for impact assessment. So I would love to hear more about what that means, what it entails, and the kind of work that you have done at the Institute.
Yeah, thank you. First of all, it's important. Alongside the brilliant panelists with excellent points, So yeah, as you mentioned, I'm part of the ethics and consolidation team at the Accelerator Institute, and our team was essentially mandated by the Council of Europe's National Community on Artificial Intelligence, to develop and propose a methodology for risk mitigation, risk and adverse impact mitigation. And the full name of that is the Human Rights Democracy Law Risk and Impact Mitigation Risk Assessment for AI Systems, but we'll just call it HUDARIA because it's kind of a mouthful. And as we know, this methodology was adopted at the end of November of last year. So I might begin by kind of giving some insight into the wider context around the area and how it came about, and then kind of dive into the specifics of the methodology itself. So my team has been collaborating with the Council of Europe since 2020, starting with the co-development of the primer that was mentioned, that was on AI human rights law, which was prepared to support the and essentially the primer was aimed at a general non-technical audience, and it gave an introduction to key concepts around how AI systems operate, what kind of opportunities and risks they present, also thinking specifically about what their impacts can be on human rights, democracy, and rule of law, and then also studying and thinking about what compliance mechanisms are needed to support the international what became international work. So following on from the primer and the subsequent research activities that took place within multi-stakeholder consultations, our team produced this kind of extensive end-to-end proposal that combined principles-based human rights due diligence with this socio-technical approach to governing AI systems, which we think is critical to supporting a responsible AI ecosystem. So since then, our team has supported the drafting of the Framework Convention and the subsequent area methodology, which is essentially kind of this process that I just described. So that's kind of where the area methodology originated from. Now the question is, what is the methodology itself? So it's essentially a multi-step governance process that provides a structured approach to carrying out risk and impact assessment for AI systems. Of course, we're going to do human rights law. So it does take up this unique role of operating kind of at the intersection of standards as well as existing technical approaches to risk management in the space of AI. And just to clarify, the HUDARIA is a standalone methodology. It's not legally binding, and it's not mandatory in any way. It's simply provided as guidance to be taken up both by private and public actors. And the intention is that it can be used and adapted flexibly, and in its development it was created in mind with being interoperable and compatible with existing approaches that are in place. So basically, in looking to kind of help actors both identify and mitigate adverse impacts, the HUDARIA methodology takes an anticipatory approach to governing AI systems and to thinking holistically across the AI system lifecycle, so across line development, including decommissioning as well, which of course integrates with considerations of the environment. So the interesting and kind of important part, of course, is kind of how the methodology of risk and impact assessment can actually be carried out in practice and implemented to kind of support the overarching obligations of the Framework Convention, which, as we know, necessitates an assessment and a mitigation of risks and adverse impacts. It might not be exactly this tool, but that's an obligation of the convention. So the methodology itself is composed of four core components, which I'll speak to in a moment, as well as this overarching kind of ongoing process of iterative review and assessment and reevaluation, which is super critical, as you know, especially in this space within artificial intelligence and machine learning that is sometimes moving at a fast pace with shifting conditions and circumstances and subsequent impacts. It's really essential to have that iterative element ongoing. So I'll kind of give an introduction, brief run through those 4 elements. So we begin with the context-based risk analysis, or COBRA, which essentially is intended to conduct kind of an initial mapping or collection of information, which is needed to kind of understand the risks that AI systems pose. And the COBRA provides a structured approach to anticipating and to considering the activities that will be required for risk management and impact mitigation. And it's concerned and focuses specifically on 3 contexts: on the systems application context, the systems design development context, and deployment context. And so the COBRA provides this preliminary analysis of risk factors that's really essential in having this initial overview of where harms may arise and what the potential impacts may be. And specifically in COBRA, we want to kind of focus in on the scale of the potential adverse impacts, their scope, the reversibility of these impacts, and the probability of these occurring. And I think, kind of just to close on COBRA, I think one of the most important parts that we're going to use is this question on this part on asking the 0 question, which essentially is about being really reflective about whether the benefits of deploying the AI system actually outweigh its risks, or if we're just getting in further trouble by deploying this system, if the AI system is appropriate or even responds to the issue at hand, and whether it will actually support equitable outcomes or not. So the second element of the criteria is the stakeholder engagement process, or SEP. And this is a super important element that aims to ensure that the views and the perspectives of those that may be potentially impacted by the activities of the AI system are meaningfully incorporated throughout this process of risk and impact assessment. And I just want to emphasize meaningfully because we've seen how stakeholder engagement can sometimes be carried out in tokenistic ways, and the intention really with the SEP and the area is to really emphasize the importance of involving stakeholders from the outset, not just in later stages, to be able to feed in and impact decision-making processes to ensure that we're fostering transparency and trust within AI practices and kind of the wider ecosystem. So the SEP works to identify salient stakeholders that may be affected by or that may affect the activities of the AI system. And we're particularly paying close attention to stakeholders that may be disproportionately at risk, those that may be especially vulnerable to harms or potential harms, and those that historically have had limited ability to influence decision-making processes across design development. And I think one of the most interesting parts of the stakeholder engagement process is this section on positionality and reflection, which is intended to be a very reflexive exercise that the project teams that are carrying out the area can undertake to identify and pinpoint which viewpoints may not be represented or not present or missing in this assessment, and make sure that we're bringing in additional expertise and insight from external stakeholders and potentially human rights experts, etc., to kind of strengthen the assessment of potential and actual impacts. We now have the actual risk and impact assessment itself, which is working to kind of contextualize and to corroborate the risks, the potential harms that we had identified in the previous stages of COBRA and SEP, and to also bring up any further potential actual harms that may come up. And this takes an exploratory approach to identifying how these impacts could occur, and then it assesses the actual risk variables that I mentioned earlier about scale, scope, reversibility, and probability. So once we've identified and assessed the potential and actual adverse impacts, it's essential to have impact mitigation measures and plans in place, as well as access to remedies that are clearly accessible by those that can be affected. And this is what we call the mitigation plan, which should take a very holistic approach to kind of mapping out the various interrelations and interdependencies of impacts, and especially how those may pose disproportionate harm or risks to certain persons. So at this stage, the area also provides a hierarchy for mitigating adverse impacts, where the priority really should be on avoiding those impacts entirely before moving on to mitigating and then thinking about restoration or compensation. So just to kind of wrap up, that's kind of like a quick review of the Q-area methodology, and later this year the CoE will be deciding on the Q-area model, which will aim to provide a much more detailed and practical guidance and resources that actors can take up. The term that keeps coming up in the plenaries is this library of knowledge, so making sure that there's really clear practices that can be taken up for the effective implementation of this
Thank you so much. So all of these documents, I mean, the Framework Convention, as well as the area methodology that was just explained, are all available on the Council of Europe's website. And they're quite dense set of documents, I have to say. Thank you very much for walking us through some of the stages and the steps in that. And the explanatory reports to the convention. So all of these documents are publicly available for review at this age. But of course, this is a convention that hasn't yet been ratified, as far as I understand, by any member states. So we will see. It would technically come into force if, I think, 5 states actually ratified, and a couple of them have to be Council of Europe. 3 of them have to be Council of Europe member states. So thank you very much. I'm very happy to open the floor for questions from